Well, that was Amy Coney Barrett, of course, only the fifth woman to seek entry into the hallowed halls of the Supreme Court, following in the footsteps of O'Connor and Ginsburg and Sotomayor and Kagan. So joining me now to discuss is trial attorney Seth Berenzweig. Seth, thanks again for being with me. And I want to go back to something that she talked about in her statement about judges not making policy and talking about, this idea that she may be someone who's able to strike down, because of her presence on the court, strike down the ObamaCare Act. And how does that play into that idea that courts don't make policy when we're talking about a law that has bounced around Congress for 10 years and still came out as a law, and now she's going to go into the court and perhaps maybe strike the entire law down?
Great question. And I think that was really one of the hot potatoes that was being tossed around today, where the Democrats are basically coming in and saying, look, we are concerned that she could, in a 6-3 realignment, toss Obamacare completely, and the Republicans came in and were just trying to downplay that. I believe that from an originalist perspective, first of all, we know there's a crack in our crystal ball. We don't exactly know what's going to happen with the ruling and how she will come down. But there are some things that we do know. We do know that just a week after the election, the Affordable Care Act case is going back to the Supreme Court for hearing. We know that it was a razor-thin decision where the Chief Justice ruled that this was an appropriate exercise of congressional power, concluding that the individual mandate was akin to a leveling of a tax and that therefore it was constitutionally empowered and it was okay. We also know that Judge Barrett has been critical of the Chief Justice with respect to that aspect of the ruling. And now that it's going back to the Supreme Court very soon, where the individual mandate tax payment has been brought down to zero, that will be very difficult for it to now stand as a tax. And if there is a determination that the enactment is not severable, the entirety of the Affordable Care Act can come collapsing down based upon her and her colleagues' rulings that could affect the insurance coverage for about 20 million Americans. So I think you're raising a very important and legitimate question. It would be foolhardy of me to say that I know how she's going to rule, although I think that a lot of people on Capitol Hill today were trying to say that they know exactly what's going to happen. But it's going to be a big deal, and that is coming down the pike very soon.
A big part, Seth, of the public trust in the court is that they have this appearance of bipartisanship, that they're not subject to these partisan issues. Now, if she walks into the court, and even if legitimately, because I agree with you, I think on some level that decision is not on solid ground. If she comes in and there is a change in the law, it's struck down, let's say, lots of people affected, but it is sort of a solid decision based on her judicial philosophy, will that still undermine sort of the public trust? Because, again, it's going to look like it was a partisan decision.
Absolutely. And that's really one of the conundrums that the Supreme Court has been facing increasingly over the years. Over the last couple of decades, and certainly in recent time, including not the least of which is Bush v. Gore, the Supreme Court has been gradually obtaining a reputation of being politicized. And when you have these 5-4 decisions, it's very difficult for the court to really avoid the possibility of getting enmeshed in political disputes. But, the Chief Justice in the prior ACA case in deeming the individual mandate to be a tax was really reaching a very creative intellectual way to reach a conclusion to save the law. If you end up in a situation now where the ACA may collapse within the next few months, that will certainly have a political ramification. And really fast forwarding to the election, we have a lot of litigation right now that's slowly bubbling through various courts spread out throughout the United States. It is distinctly possible that one of those cases is going to end up in the Supreme Court, and we might end up with another Bush v. Gore scenario. So I think you're absolutely right. It's very difficult for the court to avoid the tinge of politics, and really, it increasingly so as we're living through this very unique and historic time.
Yeah, you bring up Bush v. Gore, and that's very prescient because obviously, President Trump has made many intimations that he is going to challenge any election that he loses. He's already setting the stage for that. And there's some suggestion that he wants her on the court for those cases as they come. How do you see that playing out?
Wow. I mean, you talk about something that's a very controversial element. Listen, I think that we would have to be fooling ourselves to think that that's not an element and an aspect of the president's thinking in trying to get this nomination through. And inevitably, that's going to be an unavoidable aspect of this appointment. But it really circles us back to the Merrick Garland situation. I mean, really, do two wrongs make a right? I don't think it was appropriate the way that that was handled at the end of the Obama administration. But does that mean that now, because of the sensitivity of the timing and the fact that Judge Barrett could indeed cast a very decisive vote in a divisive political issue, would that mean that that should preclude the ability of the Senate to be able to vote on her nomination? That's really the core of what we're talking about. It's really what the Democrats are complaining about. Personally, I don't believe that two wrongs make a right and that it really should be proceeding forward. But I think that you've really touched on a very critical element, because when it comes to the ACA, when it comes to the election, when it comes to Roe versus Wade and the Casey progeny, these are things that are going to be a really big deal to people throughout the United States.
There's a school of thought, or even some polls that have been done, court watchers who have, studied these things, say that oftentimes they'll find over time many of the judges, specifically the ones on the conservative side, may slide towards the center. We've certainly seen it with a number of judges. Justice Roberts comes to mind, that he finds himself in a position where their votes can make a big difference, and there are other pressures. There's the pressures of the other judges, there's precedent, there's all these other things, the effect it can have, the policy of things that are going on throughout the country. Do you agree with that, the sense that you can't always tell, because sometimes these judges over time may move to a more centrist position?
Oh, absolutely. I think there's a crack in our crystal ball. The senators today were really pontificating as if they really knew exactly what was going to be happening. Maybe they're all smarter than we are, but I agree with you completely. I mean, who knew that Justice Gorsuch was going to be a critical vote in expanding the rights under Title VII for employment discrimination, a right that arguably was not even set forth in the statute? Who would have imagined that in the aspect of the Affordable Care Act, that a generally conservative Chief Justice would come in and really save the day for ObamaCare? So I think that we always have to just kind of take one step back and ultimately try to place our faith and trust in the institution itself, which is why it really is a delicate tightrope to try to let the Supreme Court have the space to make these decisions, even though a lot of these matters are very highly politically charged.
Yeah, I agree with you, Seth. They're such an important part of our process, our government. It's important to give them the room to do the work that they've been charged with doing. All right, Seth Berenzweig, please stick by. We got a lot more coming up.